I think it's time to start. Dear participants, dear panelists, on behalf of the French Embassy and the French Institute in Sweden, I would like to thank you for taking part in our webinar on climate justice today. This is a co-organized event with Stockholm Environmental Law and Policy Center at Stockholm University and the Administrative Court of Lyon. We have the pleasure to welcome Mrs. Hélène He, who will moderate the discussion. Mrs. He, you are Professor of Public International Law at Erasmus School of Law in Rotterdam, and Adjunct Professor at the Norwegian Center for the Law of the Sea at the Arctic University of Norway, and advisor to the Center for Environmental Law and Policy at Colombo University in Sri Lanka. Your research interests include international environmental law, law of the sea, and international institutional law. Mrs. He, you have the floor. Hélène, I think you have to put your mic on.
Of course, I forgot. Thank you very much, Emmanuel, and thank you for your kind introduction. And I also thank the French Embassy in Sweden and the Institut Français for inviting me to chair this afternoon's panel discussion. I welcome all the attending individuals, and of course, a particular welcome to the two panelists, Marc Clément and Jonas Ebbesson. Before introducing our panelists, I would like to inform the members of the audience that you are welcome to share any questions by way of the Q&A function, so not the chat, but the question and answer function. And I will try to weave those questions into the discussion or take them during the last 20 minutes of the session. We start today's session by two 5-minute introductions to the topic by each of our panelists. And I will first introduce both panelists. Marc Clément is a presiding judge at the Administrative Tribunal of Lyon in France. He's a member of the French Environmental Authority, as well as a member of the Deontological Committee of the Radio Protection and Nuclear Safety Institute, and he's a member of the Aarhus Convention Compliance Committee of the UNECE Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters, also known as the Aarhus Convention. And I can now introduce Jonas a bit shorter because I've introduced the Aarhus Convention. Jonas Ebbesson is Professor of International Law and Director of the Stockholm Environmental Law and Policy Center at Stockholm University, and he is the chairperson of the Aarhus Convention Compliance Committee linked to the earlier named Aarhus Convention. Marc, the floor is yours for about 5 minutes.
Thanks a lot, Hélène, and thanks a lot for the invitation for this presentation. I will, we promise to have very short presentations first, just to set the scene and to give the main elements for the discussion. And I invite the audience, as Hélène did, to prepare some questions and to allow us to have a very lively discussion on this. So first thing I wanted to say is that these issues of climate actions are now very lively, and we've got many cases in around the world. Specifically, in the very last month, we had the Uganda case by the end of 2019 in the Netherlands that imposes some measures, additional action on the government of the Netherlands. We had then later the end of July 2020 the Friends of the Irish Environment case in Ireland, which is almost going in the same direction, asking for the Irish government to develop additional measures to fight climate change. But we had very recently in France two different but important cases. One is the Grande Sainte case, decided in November 2020, and the case of the Century issue. That's the name of the NGO, the NGO being the applicant in this case, which was decided by the Administrative Court of Paris in February this year. So these are important cases. I just want to summarize the very main features of the two French cases. The two cases are very different from their starting point. The first, the case in the Council of State is a demand for additional measures to reduce carbon emissions. The applicant, the city of Grande Sainte, asked for more measures, and there were no reply from the ministers and the president of the Republic, and then they filed a case in the Council of State, so asking for more measures. Then for the Paris Administrative Court, the case of the Century case, this case is centered with the idea to compensate the damages that were happening following the lack of action in the domain of climate change, but damages that are the damages of from the point of view of the NGO. And then what is important is that with two very different points of departure, then the main body of the judgment of the Paris Administrative Court and the case and the judgment of the Council of State are centered on the same grounds. The first thing is to acknowledge that the state fails to meet its commitments as regard the carbon emission targets. In this domain, both Council of State and Paris Administrative Court start with the idea that in French law, it was decided that for having a possibility to meet the targets of 2050, which is the target of zero net emissions for greenhouse gases. Because of this target, there were a need to have a path to go down this road, and the path needs to have to meet carbon emissions budgets every year. Having failed to meet the first budget, the court, the Council of State, and the Administrative Paris Court acknowledged the fact that the state has not met its commitments, and there is a failure in doing so. So that's the first step. And the second step is exactly the same in both cases, is that both judgments are preliminary judgments that are just there to ask additional information from the state to be provided and to be able to decide for the courts to decide later on the cases. So that's exactly the main body of both judgments. And then there will be additional judgments following these preliminary judgments in both cases, and the judgments may lead to injunctions to take action in the case of Grand Sainte, that is the Council of State case, or injunctions to take action to compensate damages which were occurred by NGOs in the context of the Paris Administrative Court. So that's rapidly presented. What are these two cases about? I just stop here to not to be too long and to keep my 5 minutes presentations, but when we will come back on these different issues. Thanks a lot.
Thank you, Marc. Thanks very much. Jonas, the floor is yours if you want to share your screen.
Thank you, Ellen, and thank you, Emmanuel, for the introductions. I'm very glad that we could organize this event. It's a great opportunity to learn from the cases in France in particular, and also to examine Swedish law in light of the two cases, the Grand Sainte and the case of the century in France, but also in light of the Dutch case, the Urgenda case, which is rather different. So what I would do, I will indicate, just give a brief background about the Swedish legal system and what possible ways there are to bring the states or also private entities to justice. So as far as the state's responsibility is concerned, we do not have any cases in Sweden like the French or the Dutch cases. I will explain in a little while that that doesn't exclude such possibilities in the future. Just mentioned by a few rather diverse examples that we do have cases in court dealing with climate change issues, but they are not brought as civil actions. They are rather appeal of administrative decisions or part of a permit system. So just as examples, one such case concerned the biggest Swedish refinery, which was, I think, the second biggest emitter of CO2. It was brought as a permit application from Preem, and as it started, it was not at all a climate case, rather the opposite. The refinery is part of the EU's emission trading system, so it dealt with everything except for climate change. The permit by the first court of the first instance was appealed to the Land and Environmental Court of Appeal, and before that court decided on the merits, the government requested that the court, instead of deciding on it, only made an opinion, and then the government decided to decide on the case itself. I will leave aside whether the legality and the issues about that process. Anyway, it ended without a ruling because the company finally withdraw its application, but there were a lot of interesting issues about the relation between the emission trading system and the possibility of denying a permit at all for a company which is part of the trading scheme. The second case is the opposite, is a rather small case to show that even in small cases, the supervisory body and the court can confirm that it is possible to request that they take certain measures based on the general criteria or the general principles of the environmental code to take action so as to reduce emissions of greenhouse gases. In that case, it was the change of a heater or heating system. And finally, just to indicate a very different case, which I think is now possibly in the second instance, where a municipality applied to build a wall to protect against floods. So that is rather with respect to adaptation than mitigation. Just to indicate that we have had some such cases, but not anything about state's responsibility. Now, what possibilities are there and what procedures are there? We have a specific law in Sweden about the request for judicial review of the government's decision, and there could be possible situation where that could be used, but it cannot be, applied to challenge the general responsibility of the government for lacking to take sufficient action to address climate change. In this situation, since there are no other legal routes to do that, to challenge the totality in the way you did in the Urgenda case in the Netherlands, or in these cases in France, the only option would be to bring a lawsuit through a civil action. We have never had such a case before, but again, that doesn't exclude that it would be possible. We will come back to issues of standing later on. I will not address that now. One possible ground would be to look at the Climate Act, which obliges the government to provide a plan to follow the trajectory or the goal set by the parliament about phasing out CO2 emissions, etc. And if that is not done accordingly, that could be a possible legal basis. The other one would be to build on the European Convention on Human Rights, in a rather similar way as in the Urgenda case. A third ground, which is now heavily discussed because there is preparation, it's said, of such a case, is to build on the act that implements the UN Convention on the Rights of the Child. Now, as you may be aware, it is very different to apply that convention to the European Convention on Human Rights because there is no jurisprudence to build on. I would argue that the Convention on the Rights of the Child and the implementing act, it is applicable to climate change. It doesn't exclude it prima facie, but it is far more complicated to build a case on that one than on the European Convention on Human Rights. And then finally, before I will give back the floor to Ellen, it would not be, I say, possible to build a case only on the Constitution, but I think in allocating and in showing that the state has a responsibility, in addition to these three acts that I mentioned above, also the Constitution could be relevant. As far as I'm aware, it has never been applied by a court in any specific case so far dealing with the environment, but it sets out in very general language that the public administration or public institutions shall promote sustainable development leading to good environment for present and future generations. So in addition to the other act, it supports the idea that the state has a particular responsibility in these cases. But I will stop there now, Ellen. I think this is just a bit of background, and also I would like to come back to that again in light of the experiences in France and the Netherlands. Thank you. Microphone, Ellen.
One of the issues that we discussed and when we were preparing this is that we would first tackle the issue of standing, which it's very interesting how in France it's the administrative courts, in the Netherlands it was a civil action, and I hear you, Jonas, saying that you think a civil action would be the only possibility or the most likely possibility in Sweden. So maybe who would like to, I mean, it might be interesting for our audience also to talk a little bit about how accessible the French administrative legal system is, which is similar to the Netherlands, even though here it was a civil case. But so Marc, maybe if you could.
Yes. For both cases, the case in Paris Administrative Court and the case in the Council of States shows very clearly the different situations as regard the different applicants in the cases. For the NGOs, this is most of the time very easy. Depending whether in the bylaws of the NGOs you have clearly indicated that the NGO is set up for environmental purposes, and this leads almost automatically to the possibility to access the court. So this is not a big deal. For cities, in the Grand Sainte case, this is quite interesting because Grand Sainte, they are a city near the sea, so they argue that due to the threats linked with the increase of sea levels, then there will be a potential threat on the territory of the city. Then, because of that, the Council of State considers that they have an impossibility to access to court in the context of climate change, and they also admit possibilities to intervene, which was the case for Grenoble and Paris. Both cities are not close to the sea, So basically that means that for climate change, any type of configuration for cities will be okay for granting the possibilities to access to justice. However, for individuals, it seems to be the threshold seems to be a bit higher, because the mayor of Grand Sainte presented its case, presented the case as well as Grand Sainte, so as an individual applicant. So it seems that it's a bit more complicated, although it is not completely impossible. I got the feeling that you need to demonstrate some kind of special threats attached to your situation. I'm not even sure that a property with a risk of floodings, or if it is not well documented, it's not necessarily easy to access to justice. But in general, I think there is no big issue for finding at least an NGO being able to bring a case to court.
Interesting. Thank you. How is that in, because I'm surprised that in a country like Sweden, you couldn't go to the judicial review route, that you would actually have to go the civil route.
First of all, we also have administrative courts, and but they are, you do not as an individual address them usually by a application the way the French cases indicate, but they are rather used to appeal administrative decisions, well, also administrative omissions you could do so, but we wouldn't bring cases in the way that you see in the French system. The possibility of requesting a judicial review of the government's decision would mean that you would go to the Supreme Administrative Court, and you could do that if a government's decision affects your civil rights, and it is very much linked to the European Convention on Human Rights. But you cannot use that to order, to request that the court orders the state to take certain measures like you did in the Dutch case, for instance. So, and in the absence of other legal procedures, that is why I would conclude that the option available would bring it as a civil action, whether you build it on the European Convention or you would do it under the Climate Act. And as far as standing is concerned, again, we haven't experienced these kind of cases, but I would say that the Swedish court, as far as NGOs are concerned, they have understood to apply and look at the Swedish criteria in light of the Aarhus Convention, and given standing and rights for NGOs to appeal, even in cases where it's not set out clearly in the legislation. And I think that the court would do so also in a civil action. As far as individuals are concerned, we have had environmental cases before, both of course for damage and also for injunctions or for measures. In these cases, the courts do not bother too much about the formality of standing. They are rather, as soon as you you claim that you are somehow affected, the court would look at it on the merit rather than on formal grounds on standing. But you would need to say, or to with some explanation, that you are affected. Even if you build the case on the European Convention on Human Rights, that would still, I say, allow NGOs to bring such a case, even though they would not consider themselves as directly concerned, but more generally on Article 9.3 of the Aarhus Convention.
Thank you very much. I just want to remind the audience that if you are welcome, there we have our first question. I will read that in a minute. So very different situations, but in both countries, there would be, you think, a possibility for NGOs and possibly individuals. Okay, Jonas, one more question on why the Convention on the Rights to the Child. Do you have more background information on this?
Why they are considering to use that? The group that is preparing this case has good relation to, or also building it together with youth, with young people. And it was quite recently that the Convention on the Right of the Child was implemented by means of reference. So essentially the act says that the following articles of the Convention on the Right of the Child should be applied as Swedish law. So there is a quite great expectation that it would be used. So I think that is one essential reason why they would like to test it.
Yeah. Okay, thank you. Well, maybe now that we're dealing with, I have a question here, which I'll read out. I'm interested to know, this is from Jan Darpo. I'm interested to know more about the legal basis for the climate action. The Hoge Raad, the Dutch highest court, applied the European Convention on Human Rights directly, but it seems to be the only highest court in Europe to do so far at least. The Norwegian, German, Swiss, and I think the Irish Supreme Court have either dismissed those grounds or used some other legal basis for allowing them. And then what about the French cases? I think a very quick remark on my part on the Dutch legal system. Based on our constitutions, treaties that could directly apply directly in the Netherlands. In fact, the human right, we call the European Convention on Human Rights our constitution, because our courts are not allowed to review against the constitution, but they are allowed to review against the European Convention on Human Rights. That is a rather unique situation, but that's why our court was able to do that. Now, maybe what about the French cases is the follow-up question. Why do you think they moved away from or stayed away from the European Convention on Human Rights?
The first thing I wanted to say is that the situation in France was very close to the situation in the Netherlands. The courts had no possibilities to review the constitutionality of the laws until at least the mechanism put in place in 2008. But it's still very important, the role of the Convention on Human Rights in the case law of the administrative courts. A very, very substantial element. However, I think what makes the difference is that the reasoning of the Council of State was based on the fact that these national strategy and the carbon budgets were not met, and if you just allow me to show you a diagram on this, that will possibly explain the situation. And I think this is the reason why I think you see the diagram here. This was the national low carbon strategy as it was planned for France. So you see that in 2050, the objective was to have neutrality in terms of carbon emissions. For doing so, you need to have a decrease of the emissions, and you see that the first budget, which was for the years 2016-2018, the target was missed, and because of that, then the situation was relatively easy for the courts, because you can say that, and it's well documented without any type of discussion on that, you can say that we are not on the path to meet the 2050 targets. So I think it was stronger than relying on Article 2, Article 8 of the Convention, where the targets and the objectives are less easy to put in very specific and well-documented the targets. And because of that, I think that it was the choice made by the Council of State was to rely on that. And I can expand a bit later on that, but I think it has also added values as regard the separation of powers, and also as regard the possibilities to find very objective ways to measure the effort that have to be done.
Thank you.
Can I just follow up with a question? Because I think it's interesting. So the court in France would have been able to look at and would that have been done then on if that would have been claimed, or could they have picked that up ex officio? You say, even if the NGOs in the case of the century had not referred to the Human Rights Convention, would the court have been able to look at that still?
No. It was already. I think it was mentioned in both cases, but the judges did not use it for some reasons. In the context of consent, I think the views of the Council of State is that Article 2, Article 8, as regard the protection of the environment, are not precise enough to allow that in the context of climate change, you decide that the threat is so huge that you more or less falls under the conditions that the Court of Human Rights has put on these issues. I think it's something that can be discussed, because the Court of Human Rights has applied Article 2 and Article 8 in cases where threats to life were very obvious, but also in cases where it was not so obvious. So maybe.
But I think it was also, I read somewhere that it was the causality issue, that how could you blame France, at least for, the specific damage, because there's so many other emitters. That apparently also, but of course I am no expert. Jonas, you have your pen.
Yeah, and I think this, again, I was very impressed when I read the Dutch rulings. Of course, I think it's very important to have in mind, as you said at the outset, Ellen, that was a civil action, which also means that the court is bound, as I understand it, by the claim. So they asked between 25 and 40% reduction. So that was what the courts were looking at. So it actually had a way to justify, to reason how it could set that limit to 25%. But the Dutch court, I think one of the key messages there was exactly on this point with respect to the European Convention on Human Rights, because the government argued this way: Netherlands only represents less than 1% of the global emission. And the court was very bold and dismissed that quite quickly to say, no, you have to do your share. Every party to the European Convention has to do its part.
Can I just, I think there's, Christina Malin asks a question. And basically the question says, if you think about the timeline and these cases and taking action, the time it takes, considering the urgency of the matter, can the process be speeded up? And that, of course, relates to the title of our seminar. Is it effective to go to court? Because it takes forever. Some courts, get rid of the case or dismiss the case. What do you think?
So, would you like to start, Mark?
Maybe what I can say is that the first thing to take into consideration is the fact that these different cases are special cases for the courts, because the judges in this context are not only looking at past situations, and it would be the case in many cases in general. Here in climate change, what we have to take into account is the situation in the future, and to anticipate to some extent to the way the targets will be met or not in the future. What I explained here in the context of the French cases is that what we are saying is that we were above the carbon budgets in the recent years. So it means that later the targets will not be met. And I think this is a huge change in the perspectives of judges. Most of the time, we would have believed that if the government is saying, okay, now we have not met the targets, but next year that we will anticipate and we will be faster than we have done what we have done in the past, then I think most judges will tend to think that this is difficult to decide not to believe the government. And I think the change is a major change in these cases where courts are asking for more action. Having said that, I'm not sure this will be fast enough, but I don't think we have many other options, and I think it's important that we have such type of action, even in the context of the Grand Sainte or in the context of the case of the century. It has not taken 10 years for the court to decide the cases. So I think it has an impact. Not necessarily, it will not solve necessarily all the situation, but it has an impact.
And which is also, I would say, an advantage of the French administrative system, that the court rather quickly decides cases compared to some other jurisdictions, I would say. I don't know how this would be in Sweden. Imagine the NGO starts its action.
Yeah, I think the question is general, and I think it must be replied to given the context that we see this huge number of lawsuits around the world on climate change issues more generally, and there have been a few cases against the states, not only Europe, but also in Pakistan and Colombia, for instance, which have been successful. So I think there is some hope in that this would resolve things. And I think it's important to come back to what the courts can do and what they should do. And the point that Marc made is important. If you have a legal framework with carbon budget or a trajectory to be followed, and if that is not followed, I think bringing the case to court could be a way to speed up, so to say. I mean, to implement and to ask the government to do what it is obliged to do. So in that sense, I think it's clear. It's more tricky when we look at the European Convention for the reason that you stated. You cannot really read out what to do, but it's a way of how you construe, how you understand it in light of it. And of course, the court can in that case be blamed for legislating rather than only applying the law. But the Dutch court was very well aware of that it did not go into the position of the lawmaker. And I think this comes back to the question then about speeding up things. I think the climate change politics has to be made elsewhere. The court can speed up and ensure the implementation, and can also, I think, indicate the insufficiency of existing laws. And in that sense, I think it's an important element, and I think it's very important now to show governments that they can actually be held accountable.
Yes, this also brings us to a question that Daniela Owona asked. I was wondering if litigants, no, wait a minute. Sorry. There it is. It was Chiara O'Connor. Thank you for the interesting seminar. Is there evidence of a reluctance by the judiciary to intervene in climate change cases due to the tensions regarding the separation of power? I mean, Jonas started to address that question. Well, obviously in some cases not, I would say, but maybe in others, yes. But of course, it raises a much bigger issue, the separation of power. Your views?
My impression when looking at this is that the courts are not reluctant as such to look at climate change. I think there's also a very important message to say that in all cases, those well-known cases, courts take climate change seriously. I mean, we do not have any climate change deniers or skepticists in the courts. I think you can see in the Dutch case, there was a lengthy description about that. In other cases, like in the Colombian or the Pakistani case, they simply take it seriously from the outset without further elaboration. And I think the French cases show that too, that the judiciary take it seriously. The Norwegian case that was mentioned before by Jan Darpe The court took climate change also seriously, and it also looked at the European Convention on Human Rights, but then it didn't rule in favor of the NGOs. But I think that they are not as such reluctant to deal with it. And just a few last word, I think that the procedure of the European Court of Human Rights, now in this case with the 33 states, we don't know yet whether the court will dismiss it at the end, but the way it proceeds, I think, shows also an interest. And we may come back, I have some of my thoughts on why it does it, but it shows an interest of dealing with climate change in the courts.
Mark?
No, I think the issue of separation of powers is a very sensitive issue, and I think in all jurisdictions the judges are paying a lot of attention to that. I think, however, that we are not missing of commitments, legislation in climate change, especially in Europe, but I think in many countries you'll find a lot of commitments and text adopted by governments, by states, by legislators, indicating they commit to limit carbon emissions. And in the context of European law, we've got the conventions, the Paris agreements, we got the directives, and we got national laws adopted. If you look at the Grand Sainte case, and the Paris Administrative Court case, you'll find these texts that are explicitly quoted by the judges in both judgments, having the three levels: international conventions, European law, national laws. And this clearly shows that in this context, the judge is just trying to analyze these texts and to take to draw consequences from this text. And to me, this is clearly not stepping on the shoes of the executive powers or legislative powers.
I would agree with you, Mark, that I think from the court's perspective, they're would be more comfortable to applying the French, doing the French way, so to say, because, and I think also if a case is brought in Sweden, where we have a climate act, and there it's related to the parliament's goal, climate goal, which is to be climate neutral by 2045. So, and if the Council on Climate Policies, and if the scientific community or the Environment Protection Agency would show that the trajectory goes far away from what is intended in this law, I think the courts would be more comfortable in that case to show that the government doesn't do what it's obliged to do by the Climate Act, rather than going into this still quite difficult question of applying Article 2 and 8 of the Human Rights Convention.
Yeah, and I would say it doesn't live up to what it says it was going to do.
Yeah.
And that, yeah. No, and I think reading and looking at some of the older cases again in preparation for this, I think most courts have also treaded very carefully. I mean, they're obviously well aware of this. So yes, I'm not sure there's a big problem either. Jonas, you said you wanted to say something about the case in the European Court of Human Rights.
Yeah, well, we don't know yet what will happen in this case, but I think quite a few colleagues with me, when we first heard of this case, that there was 6 youth in Portugal who brought 23 states to the court without using up the domestic remedies in any of these states, and also without spending too much energy or words to explain why. And there is also this aspect about extraterritoriality. I think that there were quite a few who would think that the court would dismiss that case. And of course, it is still possible that the court will do so at the end. And it's usually the court would ask the responding state about its view about admissibility. So that is not so strange. But the way it proceeded with this, it didn't only ask the government to to give their views about admissibility, but also in a very comprehensive way to explain what they have done, their climate policies, how they see that in light of the Paris Agreement, the Aarhus Convention, by the way, other principles, and also to give their views of the application of Article 2 and 8. And then I don't know whether it was an error or not, but the court also refers to Article 3, which is about torture. But leaving that aside, so I think the court, I would think, send this message to the governments, and that it is open, that it is relevant, the convention. Possibly, I would think that it would be worried if national courts, the Dutch court, the Norwegian, and others, start to interpret and apply the European Convention in different ways. So I think the European Court of Human Rights would be quite eager to have a case. But I would not think that it would like to have 33 defending states. I don't see it. So we don't know whether it will actually.
They've actually had that before in other cases. And I do think there is this issue now. I mean, and this is a very, what I'm going to say is a very political statement, I guess, but there is this issue of courts wanting to show that they can do this. I think they will, I mean, that does play a role. The interesting thing for our audience, the interesting thing about the case before the European Court of Human Rights, which you can find under the name Carvalho et al. In 2019, that's when it was first submitted, is that Article 14 is also raised, so intergenerational equity issues. So very interesting. But Marc, please, if you would like to comment on this case as well.
No, I don't have many things to say. I think if I would have to bet on this case, I would say that the court will not go very far. But if I would have bet in the context of the Netherlands after the first instance case and first instance judgment, I would have lost. So.
Me too. I would have lost too.
Betting is dangerous in these cases. So no, I agree with you, Marc. That was my thought. But again, the court applied this rather new process of a more speedy management of the cases. So it will be interesting to see how it deals with the domestic remedies, whether it will make this simple and say in many cases it was not, because I think it would like also to set the precedence itself, the jurisprudence itself, rather than the Dutch court, the Norwegian court, and others doing that.
Yes, I think that might play a role. We have a question from Salvador de Rosa about the role of science in these cases. And if you remember, I mean, certainly, was it the first or the second, or again, the case, I don't remember, but it was IPCC reports copied, from beginning to end in places. And I think this is going to be a complication in the follow-up of the French cases as well, where the science is going to be so important. And so, yeah, what role does science play in these cases? Would you?
No, I think it plays a crucial role, but if you compare these cases to other environmental cases, it's to some extent it's easier for the diagnosis. For the diagnosis part, it's much easier than if you had a case related to biodiversity in a spatial area where you need to collect information on many species, and you don't have this information available. In climate change, you'll find many information everywhere, and many of the states, and in the context of Grand Sainte, it was used. There is a High Council on Climate Change in France, almost the same. It was copied from the UK, and it is giving advices and opinions. And so if you have opinions from this council showing that we are not on the correct path for carbon neutrality, then it's easy for the judges to some extent. What is extremely difficult is then to decide what type of actions the state has to do following the judgment. And it is a link to some of the questions in the chat, it is obviously the difficult part of it. Once you have decided that the state fails to find the right measures, then you have to decide what would be acceptable. But I don't have any answer to that.
No, I think that's where it gets difficult for lawyers, isn't it? When you,
But I think that if I may, the role of science will depend very much on the kind of process. In some cases, I don't think that science is so much of a problem. And again, as I said, you don't need to use science to convince the court that climate change is real. I think as you say, it was the district court. Maybe it spent even unnecessary amount of paper to justify that, because it was clear that it was convinced. Then, of course, if you look at the remedies, the claims, what is done, then it may be relevant. You may know of this case in a German court where a Peruvian farmer sued the German energy company RWE, which is one of the biggest emitter in the world. It is said to amount to 0.5% of the global emissions. And this Peruvian farmer asked for compensation for the measures that need to be taken for the climate change in Peru, amounting to 0.5% of these costs. Of course, in such a case, the scientific input is quite different from the one that you have in the French case. So I think, again, science is not so much needed to convince the court that climate change is real, but rather maybe then if you measure up what is the French government expected to do when we have seen these reports.
yes, I think that's indeed where it becomes difficult, not so much in the showing that climate change is a problem. Amalia Deliuenza, could we imagine companies bringing forth cases related to climate change other than perhaps in the context of a permit issuance, such as the Swedish pre-ref, the refinery case? Yes, we can, maybe not in national court so much.
You mean that they would be the plaintiff, that they would bring the cases? Is that what you mean?
Yes, I think that's what Amalia means, that, would they bring cases against the government? And of course, BIT's, bilateral investment treaty cases, are now,
Yeah.
We do a little research on Spain, for example, the amount of investment, so companies are acting against Spain. We have a case in the Netherlands also with a German company. So yes, there are, but I don't know if I'm not, an expert on these cases, but yes, foreign companies act against the host states.
Yeah, we see those cases. I was wondering whether she also had in mind whether a company would act against this government for taking too little action. I mean, we have this, and I think it's a very good case you mentioned, Ellen, and I'm very curious to see what will happen in this Dutch case there too, which is, again, a very different case than the Urgenda case, but to see what happens. But could one also think of companies suing the state for doing too little for some reasons? I wouldn't rule that out completely for competition reason, or they could also, of course, be landowners and affected. Their businesses could be affected.
But I think it's a very important issue for the audience. I think climate change can be an issue everywhere now. Just to give you an example, Total asked for a permit for biofuels plant in Marseille, and on the 1st of April, the Administrative Court of Marseille quashed this authorization due to the fact that they have not taken in the environmental impact study the climate change effects on the planet. I mean, taking into account the impact of palm trees issues in Indonesia. So I think that in every case, you potentially have issues related to climate change. And I think it's very important not to focus only on the big cases where it is asked for measures taken by the governments and the states, but also to take into consideration the fact that even on a smaller scale, for a permit for allowing an activity, competitors, as Jonas said, could act in the context of this, of having not chosen by project which is the best for climate change effects.
Yeah. Can I join in there, Ellen? I think this is good that you mentioned that we should not only focus on these big cases about the states or the huge oil companies or car companies. My view, looking at the Swedish case, is that the environmental code, which has been in effect for 20 years, and it has always been applicable to climate change issues, have been done so far too little than could be possible. And my impression is also that the courts have been very reluctant to apply it in individual cases, preferring that this should be dealt with more generally in legislation. But I think, I mean, there are one of the cases I mentioned in my introduction indicates at least an opening for that, and there is a strong pressure, and there is now a preparation for amendments of the environmental code to insist on that and to make it more obvious. But it has always been applicable, and it can be used today in numerous cases by the local municipal supervisory authorities to impose technology. If best available technology is more climate friendly than the one that is applied, there is a legal basis for requesting that. And I think this is just as important for many reasons.
There is, Jonas, a question, I guess, for you.
Mm-hmm.
Again, Salvatore De Rosa, where he says the Swedish Climate Council has also confirmed that Sweden is not doing enough to reduce emissions. It's stated that Sweden only reduced emissions 1% in 2018, and that to keep pace with the national goals, it should have reduction rates of 4 to 5% per year. Could this provide a basis for arguing?
And this is what I think could be a potential basis. If it is a matter of 1 or 2%, I mean, now I'm speculating, maybe the court would say, okay, we cannot count it on each and every year, but if you have a clear indication, I mean, a bit like the French trajectory indicated that there would be huge discrepancies, this could possibly be a case under Swedish law too, where NGOs would bring such a case. And then the question is, and that's why I'm curious, and maybe now or later, if Marc could explain a bit the special French system with the penalties. What if they were bringing such a case now in Sweden, and the government is ordered to take stronger measures? I mean, I think there is a very strong political pull and incentive to comply with the ruling still. But we do not, just like I think in the Netherlands, we do not have any specific sanction like that. Like I know that you have in France, where even the government can be guilty and ordered to pay fines.
That's in the Netherlands as well. In a
okay.
civil case, yeah. But Marc.
Yes, it's probably a bit complicated to say all the things, but it was applied in recent air pollution cases where there was, and this is very similar to climate change, because the Council of State ordered the state to adopt additional measures to fight air pollution. The measures were deemed insufficient, and the court, the Council of State, ruled in July 2020 that the governments has to take additional measures, and every 6 months had to pay 10 million euros if not if the measures are not adopted. So I'm not entering into the details, but that's something that the administrative judges can do in the context of a lack of execution of a lack of implementation of a judgment.
So may I follow up on that, Ellen? Because I mean, I see the European Court, the EU Court of Justice can do the same. It can oblige, and there I can see the point. I mean, as a member state, you have to pay to the EU, so you really, essentially, you lose something. So I'm just trying not to find out the legal incentive. Who would, if the government is ordered to pay the fine, it pays the fine to itself, doesn't it? I mean, how does it work? I'm curious to understand the legal context.
No, I have to check, but I think either it should be paid to the plaintiff first. In general terms.
Aha, okay, so it's like damage rather than.
It's not a fine. It's yeah, that's the same in the Netherlands.
But it depends. In this specific case, I cannot I cannot be sure that this is the case. But usually this is the plaintiff to receive this.
Okay, that's
in the Paris Administrative Court case, where although they pay €1 to each of these NGOs, but I mean that's how it goes. And those in the Netherlands, in a civil law case, you could also do that, and you know the amounts could be quite large. Yeah. We've been going, just a point of order, we've been going for an hour, and that was the allocated time, but we also agreed beforehand that we would go on for a little longer if we're having an animated discussion. Are you up to this, Mark and Jonas, or are you okay? Moving on to a bit of a different question by Christina Malin. Moving from the public to the private sector, what do you think is the likelihood of I guess you mean a case before the European Court of Justice or at the EU level requiring global multinational companies with sizable carbon footprints and, you know, asking them to reduce I hope that was a good summary of the question. Do you see options for this where Shell, other large multinationals? I mean, some of this, of course, is happening, although in a very different context, but could they be taken?
It is interesting that to link this to the EU, not because you can use the Court of Justice in the EU, but because there is now a preparation of specific legislation on corporate social responsibility, also intended to apply to the companies when acting outside the EU. So I think that dimension is addressed, but exactly how such a lawsuit would be brought, on what basis, I mean, whether it is about the damage caused or whether it is because the company is not applying specific law. I would think that we will see more lawsuits against the big oil and possibly car companies in the future, although I have no clear idea how they would be put together. But most likely.
Quite a few, but maybe Mark first.
No, I think there will be a competition between courts, national courts in this. And I think this is the first one indicating that the court will take into account extraterritorial aspects of the case, will be the one attracting all the case for the EU. And I think there is some incentive or disincentive in this area. But I'm sure this will be an issue soon. Yeah, as it is for human rights issues and in the big cases.
We have that. How do we see the jurisdiction? The ties we have trying to. It's a very question by an anonymous attendee who asks whether all of this is just a way to procrastinate. Proper way. We've really dealt with that one. So who identifies the execution and enforcement of court's decisions? This is about enforcement of the, enforcement of the judges and judgments, and in a way we've talked about that, I think, where French courts even French administrative courts have, I would say, quite extensive powers. In the Netherlands, this is a bit of an issue with the Urgenda case, of course, because we haven't seen much from the government, and the three of us were chatting before. And due to COVID, that has helped the Dutch government. So that's still, it's to be seen what exactly will happen there.
Yeah, so the enforcement issue, I think it depends on whether you look at it from concern the state or private entities, because for private entities, the enforcement issue is, well, less complicated with the state. And even though it's very interesting to hear this explanation by Marc about the French system, where the fines seem to be more kind of damage or compensation to the victims. And now, since you have those huge damages, it could have an incentive. But I would think still that the legal political context, which could look different from one state to the other, would be the main incentive. I would be surprised if the Dutch government didn't show whatever it could that it take this very seriously, even though it may not be an impeachment process for the prime minister or something like that if they fail. But I think still the incentive, because it's so essential for the legitimacy of the government that it shows that it abides to the ruling of the court. So.
Yes, and I think it's relevant to legitimacy of the Dutch government or any government in more than one way, because it also wants to get the private sector to come along. And if it drags its feet, that's not going to, in policy terms, work very well. So I think there are many different reasons why this is important for the legitimacy of the Dutch government. So and I guess for any government. Pressing issues, gentlemen. Do you have pressing issues that you want to discuss? No?
No, I'm very happy to have learned from the French case, and also with you, Ellen, a bit more in depth of the Dutch experience. So I have no further pressing issue.
Marc?
No, I don't have. I think we've covered quite a number of issues which would have potentially be the topic for other webinars, but this is fine.
Okay, so I want to thank both of you, and thanks for putting up with me as the chair of this session. And I also want to thank all the participants and for your active participation through your questions. Thank you very much. And hereby we close the session.